the fact that of all the famous people that came to Canada, all the presidents, all the prime ministers, the single biggest expense was Prince Harry. I mean, that does stick in the craw.
You know, I realize I'm cancelling myself with this position.
I'm doing this as this kind of David and Goliath, although if you've got Mosley's millions, and you've got Sir Elton John and others in your
David
stable.
with a massive golden slingshot, isn't
Exactly.
it?
Fascinating moments in this case was the final day when the Daily Mail produced the most astonishing personal Facebook messages exchanged between Griffiths and Prince Harry, in which it was very clear the two had had
The bombshell at the center of this entire disaster is brutally simple. Harry's own published words have now become one of the most dangerous pieces of evidence hanging over a $50 million legal catastrophe, while the insurance safety net he was supposed to have underneath him is suddenly facing questions nobody wants to answer publicly. $34.5 million. That is the number staring back from the legal bill, and behind that number is a man whose options appear to be shrinking by the day. There was supposed to be protection against exactly this kind of financial collapse, but whether that protection still works is now another question entirely.
extraordinary courtroom verdict. Prince Harry has lost his £50 million case against the Mail, but today, as he arrives for a speech at Chatham House, the moment this devastating verdict is announced,
His name is Prince Harry, and the date everyone keeps talking about is August 28th. But there is a problem. August 28th is not actually the moment the judgment arrives. It is the payment deadline. That distinction matters because before this nightmare reached the courtroom, Harry had lived inside a world where financial consequences were almost impossible to imagine. There were palaces, state dinners, protection funded by the British state, private travel, and access to rooms where ordinary people could spend their entire careers trying to get through the door.
Officially deemed a loser. In fact, all of him and his co-claimants, there are 7 among them, were determined to be losers in this scenario, and this could not be more of a disaster for Prince Harry, especially as he begins his week-long series of engagements.
Harry was born into that world. And then there was Diana. Her name was not merely sentimental. It carried influence, recognition, and access. The money connected to Diana has never been officially confirmed at the figures sometimes reported, but estimates have circulated from £10 million to £30 million inherited by her sons alongside the Queen Mother Trust. Whatever the precise figure, the larger point remains explosive. Harry entered adulthood with financial security most people could never imagine. No mortgage pressure, no ordinary household bills, no decades-long struggle simply to build a safety net. And then Harry walked away. That is where this story becomes much more complicated, because leaving royal life and leaving while expecting the practical advantages of royal life to remain intact are two very different things. Princess Markle of Japan became the comparison. She gave up her royal status, titles, protection, and financial support, moved to New York with her husband, and accepted the consequences of that break. Harry wanted something different. He wanted distance from the institution while still retaining some of its protection and advantages. The lawsuit then was never simply about money. It was about control. Harry wanted a British courtroom to validate his version of events and establish on the official record that the press had wronged him. But behind that fight was another assumption that the money would continue coming from somewhere. Sources close to Harry and Meghan had suggested commercial ventures, deals, and their public platform would sustain the new life. But what happens when those assumptions begin collapsing at the exact moment a lawsuit becomes financially dangerous? Elton John told Harry not to bring the case. Charles told him not to. His own legal advisors reportedly gave the same warning. Yet Harry continued, and then the courtroom started dismantling the confidence behind the case. This was no ordinary lawsuit. Prince Harry stood alongside Sir Elton John, Baroness Doreen Lawrence, and 4 others against Associated Newspapers, the publisher of the Daily Mail and Mail, on Sunday. 7 claimants. Allegations stretching across 2 decades. Claims involving unlawful information gathering, phone tapping, deception, and private records. The case took 4 years to reach trial, finally opening on January 19, 2026, with 11 weeks and 45 sitting days ahead. Harry entered the witness box on January 21st, believing earlier victories might provide momentum. He had previously won against Mirror Group newspapers in 2023, while News Group newspapers reached a settlement with him in January 2025 that included a public apology from Rupert Murdoch's organization. But this time, something went catastrophically wrong. The first major crack came from the claimant's own evidence. Gavin Burrows had been treated as a crucial foundation for the case. His 2021 witness statement had been filed, reviewed, and relied upon for years. Then, under oath, Burrows said that statement was absolutely incorrect. He said he had never worked for the male titles and claimed his signature had been forged. Think about the magnitude of that moment. Years of preparation, an 11-week trial, and evidence described as load-bearing suddenly became a problem inside the courtroom itself. The foundation was no longer simply being attacked by Associated newspapers. It was being challenged from within. And then came the detail that would make this entire story far more explosive. Harry's own book, Spare. During questioning, Harry was asked about a music festival. His answer was immediate. He had not been there, but his legal team opened his own published memoir and found a passage describing Harry attending that exact festival. The words were already printed, already published, already available to the world. But the judge made one distinction that matters enormously. Miss Justice Matthew Nicklin did not find dishonesty by the claimants. On July 7th, 2026, the 436-page ruling dismissed all 97 allegations, while making clear that private information alone was not enough to prove unlawful sourcing. Associated newspapers called the result a magnificent vindication, and Paul Decker described the case as costing more than £50 million. Then, Harry made the situation even more dangerous. The verdict had been known to Harry before it became public, meaning the statement that followed was prepared in advance. Harry and Baroness Doreen Lawrence described the judgment as a whitewash, language that effectively placed Mr. Justice Nicklin under a cloud of suspicion. 5 of the 7 claimants saw the statement before publication, but none attached their names to it. Elton John read it and stayed silent. That silence suddenly became deafening because the cause hearing had not happened yet, and the same judge was still deciding what Harry would ultimately owe. The financial consequences now became the real battlefield. At the July 29th and 30th cause hearing, NL's barrister Anthony White KC pointed directly to that statement, arguing that Harry and Baroness Doreen Lawrence had continued promoting allegations that the court had already dismissed. Under Civil Procedure Rule 44.2, conduct can influence the basis on which costs are assessed. And suddenly, the $34.5 million figure was no longer just a frightening headline. It was a potential personal disaster. Before the case began, all 7 claimants had insurance. The 8 policy was designed to provide a financial floor if the case collapsed. The combined cover was $16.2 million, not the repeatedly reported $6.2 million. But even $16.2 million leaves an $18.3 million gap against $34.5 million. And now comes the question that could change everything. Will the insurer actually pay? 3 issues are being examined. First, Mr. Justice Nicklin found that 24 allegations had been pursued without sufficient evidential basis. Second, 8 policies contain conduct clauses, and Harry's contradictions between sworn testimony and his own published words are permanently preserved in the court record. Third, the whitewash statement continued the allegations after judgment, giving the insurer another potential issue to examine. Rocco Parrots of Harbor Underwriting provided the crucial qualification: losing a case does not automatically void 8 insurance. There must be something more, such as dishonesty or improper conduct by the insured claimants personally. Mr. Justice Nicklin made no dishonesty finding against Harry. That matters, but it does not make the insurance question disappear. And if the policy fails, Harry's exposure becomes terrifying. Elton John had once stood beside Harry because of his connection to Diana. He had supported Harry over the years, introduced him to David Sherborne, and helped set the chain of events behind the lawsuit into motion. Yet when Harry needed financial help for the Invictus Games, the answer reportedly changed. Paula Froelich reported that the Games faced a $25 million funding gap with only around $4 million raised. Elton John reportedly refused to become the financial safety net, with the response attributed to his camp being brutally simple: "I am not an ATM." David Furnish independently reached the same conclusion. Then came Highgrove House. On July 10, 2026, King Charles met Archie and Lilibet at Highgrove House, with Meghan present and Camilla in the room throughout. The visit was publicly framed as a family reunion, but Harry was also briefing the Daily Mirror about his continuing demand for government-funded security. That detail transformed the meaning of the meeting. What looked emotional on the surface carried financial negotiations underneath. Sir Clive Alderton was still another piece of the puzzle. On July 27th, he announced that he would step down around May 2027 when he turned 60 after 2 decades of service. The timing created speculation, but the dramatic claim that he resigned immediately after Highgrove was inaccurate. And then August 28th came into focus. It is not the day the ruling arrives. The written ruling is expected during the week of August 17th. August 28th is the interim payment deadline. declined. Associated newspapers sought $10 million. The claimants offered $8 million. The ruling will determine the interim payment and whether costs are assessed on a standard or indemnity basis. If insurance survives, Harry's personal exposure could remain in the millions. If indemnity costs are imposed and the insurance collapses, the number becomes vastly more dangerous. Meanwhile, Santabale is suing Harry. Netflix has renewed with Harry and Meghan on reduced first-look terms. Arkowell Foundation has struggled to produce the commercial results originally projected, and the Invictus Games still faces its funding gap. This is no longer one isolated courtroom defeat. It is a financial pressure system closing from several directions at once. The cost ruling is coming. The insurance question remains unresolved. The people once expected to stand beside Harry are increasingly standing somewhere else, and that is why the most frightening number may not be $34.5 million at all. It may be the amount Harry is left carrying when everyone else finally steps away.